All right, great. I think it's time that we begin, David. So welcome back. Welcome everybody to Garfunkel Wild's monthly compliance webinar series. My name is Rob Del Giorno. I'm the chair of the compliance group here at Garfunkel Wild. I'm joined by my partner, David Traskey. You might remember him from our last webinar, part one in this series. David joined us. He is former senior counsel for the OIG. How you doing today, David?
I'm doing well. I'm excited to see there's so much interest in round two. That's
Yeah,
great.
Yeah, I know. The registration has been terrific. People are joining in, and you know, today, we're here for part two of the inside scoop, behind the scenes look at the HHS-OIG. And the webinar for part two today is the OIG enforcement actions and the path to resolution. But just briefly, for those maybe who didn't join us last time, we talked a bit about um, the general interactions with the OIG and things that are important. I don't know if you want to just take a minute to give people kind of a summary about how important it is to know who you're talking to.
Yeah, thanks. So, well, I mean, a couple of things that we talked about last time, we talked about generally OIG's structure and its operations and its self-disclosure process, both the benefits of it and how to kind of go through it. We talked a little bit about some recent self-disclosure resolutions, and one of the things that we spent some time talking about was the importance of knowing who you're talking to when you're dealing with the federal government, whether it's the Justice Department or whether it's the OIG. And there's oftentimes what I found was that folks that would appear before us would always ask us about, well, what is DOJ doing with this? What is OIG going to do with this? And there's only so much information that we can provide, but there's some things that I think you can learn about from, kind of reading between the lines or behind the scenes about who you're talking to. So, for instance, if you're getting a phone call from OIG's Office of Investigations, for example, you can be pretty sure that either you're a target of an investigation or that you are someone who has information that they believe is valuable to the investigation. And that means that they're working with the Justice Department, either criminally or civilly. And I think it can never hurt to ask, on that first contact, is DOJ involved? And if so, is it criminal or civil? And who's your point of contact at the Justice Department? I also think it's worth asking whether or not the case is a delegated case or not. Cases that are delegated are handled, kind of at the local level without oversight from main justice in DC. Those that are not delegated, have the local AUSA plus oversight from main justice, and obviously the stakes are a little bit higher there. And then if you're getting a call from someone in DOJ's civil division, you can feel pretty confident that the case was looked at criminally, and for whatever reason they declined to move forward with it criminally, but now it's being looked at civilly, which I then think sort of transitions into how you get into how the ALB, the affirmative litigation branch, fits into all of this.
Right. And that's really what we're here for today, is to kind of, step into part two of the series. Just a reminder to everyone, I wanted to wait now that we're kind of jumping up with more participants. This is being recorded, and we're going to be sending it out probably tomorrow to everybody who registered for it. So if you have to drop off or at any point get that question, usually throughout these webinars, we'll be sending it out to everybody. If you have questions, you can put it in the Q&A or the chat. I'll try to monitor them, and we generally try to answer as much as we can. If it's not appropriate for a public answer, we'll let you know that as well. But let's talk affirmative litigation branch. We're here to really understand how the OIG goes about bringing its own enforcement action. So why don't you tell us a bit about what the affirmative litigation branch is? I believe you tell us you were a part of it. You have the inside look. Tell us how it's structured, its purpose, how things work. Why don't you give us an overview on that?
Yeah, so the affirmative litigation branch, it's part of the Office of Counsel to the Inspector General at OIG. It's its own branch. It's headed up by a branch chief, and underneath the branch chief there are two deputies, and then each deputy is responsible for overseeing a team of usually like 5 to 7 line attorneys. So all told, probably you're looking at 15, 20 people in that branch. And the main goal that they have, or their mission really, is they're bringing enforcement actions for which they believe that a provider has liability under the civil monetary penalties law. And there are numerous authorities that OIG has. I think over 40 now under the CMPL. And their focus really is to bring these actions and to sort of fill an enforcement gap. As we sort of talked a moment ago, DOJ, criminal or civil, for whatever reason, there are some cases that come across their desk that for whatever reason they're not able to take. Maybe it's a dollar amount issue, or maybe there's some other things going on, and those might get referred to the ALB. But really, it's to fill that enforcement gap and also to hold individuals accountable where, kind of where appropriate.
Right, right. So, I mean, you were sitting there. You had your desk there. Let's talk a little bit about how these cases originate on your end. Let's talk about how they actually come into you. Because I think a lot of our folks are more used to dealing with either contact from maybe the AG office or maybe the U.S. Attorney's office, sometimes DOJ, but here's the OIG sitting here with this oversight authority and bringing their own actions. Kind of how do you get started looking at something? And let's also talk about, then we'll move into case types and how you decide if if the OIG is gonna allocate the resources to a particular case.
Sure. So the case origination for ALB can come from so many sources. It's kind of staggering. I would say that the majority of the casework that comes through, is through a couple different sources. One, as I mentioned a minute ago, would be a referral from the Justice Department, usually from the Civil Division. Then we also have referrals from our other sort of state and federal law enforcement partners. So you think about the state AG's office, you think about the program integrity folks, both within CMS and in the state Medicaid fraud control units. There's also quite a lot of work that I did when I was there to enhance the use of data analytics as a means to identify potential cases.
So what were you doing with that? What were you doing with the data analytics?
Yeah, as you might imagine, OIG has quite a lot of data at its fingertips, particularly with respect to claims data. And sometimes, one of the things that we would be able to do is look at who are outliers in a particular practice or a particular area, and see if we can understand why, they are so much of an outlier. Like a really obvious example would be if you have somebody who is like an ear, nose, and throat doctor or something like that, and they're prescribing a bunch of durable medical equipment. Generally, that doesn't, it's not typically what we'd expect to see.
Right.
But obviously, there's all kinds of metrics that they have to determine whether or not a provider is an outlier, kind of on a state level or on a federal level.
And what kind of folks
Um,
are you working with that? Do you have auditors there with you? Do you have,
So there is a division of data analytics within OIG who helps do that work and maintains those files. So those are the folks that we would talk to and say, hey, listen, I'm interested in looking at to see who's an outlier in a particular area. And some of the information that we can see, and some of it that they can provide for us. So I think that's one of the main ways in which data analytics is being used. The other way, and I did this quite a lot, is as the audience likely knows, there's a lot of reports that are issued both by the OIG, both within its Office of Audit Services and then also within its Office of Evaluation and Inspections. And in each one of those reports, they generally are reports that focus on like a large issue or a national issue or
Yeah.
something like that. But underlying that report, there's data that they're relying on for the report. And if you drill down far enough, you can see, for example, if there was a recent report that looked at the frequency with which providers were performing facet joint injections into the spine. That report came out a while ago. And underlying that report, we were able to then identify the outlier providers who were engaged in that conduct, and that those that research and that analysis then turned into a case project for ALB, in which we were able to secure, I think it was like 9 settlements among different providers across the country.
Yeah, our providers are always asking us a lot of times, how did they find me? How did this case come about? Why are they looking at me? Or so tell me, what about the complaint, kind of hotline, or complaints coming in from, quasi whistleblowers or employees or patients or others, maybe competitors, calling up and leaving, information and contacting OIG? What about
Yeah,
that?
that's a good point, and that's another mechanism by which case origination occurs, is through hotline complaints. And I would say that as a practical matter, OIG would say, if you ask them, well, why are you looking at my client? Their answer always, almost without fail, is going to be, we don't divulge our investigative techniques and our methodologies and things like that, so we're not going to tell you. But what they will often tell you is that your client is not the only person being looked at for the conduct.
Right.
And so that oftentimes gives rise, I think, to people trying to understand how their client got noticed. But one of the things that I will say is that, in particular with the data analytics, but also just across the organization in ALB, the mission that they have is to go where the evidence leads. And so what I can say is that they're not looking to play gotcha or anything like that. And I can tell you, there was several cases over my time that I was there that we investigated based on a variety, that came to us in a variety of ways. We investigated it, we looked at it, and we determined that there was no liability, on the part of the provider under the CMPL, and so we close the case and we move on to the next one. So the one thing that I can say is that it's a pretty even-handed process.
Okay. And so we have data analytics. We have the referrals kind of coming in from our different agencies. We have these complaints that can come in independently from those things. What's the process inside the OIG, inside ALB? When you're looking at this, you have only a certain amount of resources. What are the types of cases you look to choose? What are the cases that interest you more? Is it a type of conduct? Is it a threshold? Is it because something's been on, your work plan? Is it, what are the things that go into actually sitting down and saying, okay, we're really going to put some resources into this and take a hard look at this provider?
Yeah, so it actually could be all of the above, right? So some of them come from work plan items. Some of them come from public statements that the IG herself might make. For instance, when she started in her role, she indicated that hospice and home health providers, for example, were an area of interest and concern for her. And so obviously, resources get devoted to that type of work. But I think that, kind of on the whole, I would say that there's sort of 3 big buckets of work. One would be conduct that's kickback conduct under the AKS. The other one would be what like under the umbrella of false or fraudulent billing. And then the third one would be that which is related to grant and contract fraud. And one of the things that they are really focused on is understand that when OIG opens a case, or the ALB opens a case, they're going to look at it through like a lens where there's multiple avenues to pursue it, right? So it's not always going to be medical necessity, but it could be failure to comply with the applicable regulations. It could be known retention of an overpayment. They're going to be looking at cases, I think, that do 2 main things. One, that gives them the greatest amount of flexibility from a legal and case development standpoint. And then the other one is going to be, in particular, for regulations and things that are fairly straightforward. I'll go back to my example here with the facet joint injections, right? Those rules required that providers could do a certain number of procedures within a rolling 12-month period, right? It's fairly easy for an analyst or an attorney to look at the claims data and say, okay, did the provider do this thing within a rolling 12-month? Did they do an excess number within a rolling 12 months? Or for instance, in the hospice space, right, there are special requirements to be able to bill for general inpatient hospice. Did the provider meet those requirements? So I think um, the more clear the guidance is, the more interest from a litigation standpoint
Do
or
you have any
case
particular,
development standpoint.
right? Do you have any particular dollar thresholds where you're just, you're not going to waste your time and energy, or is there,
No, I mean, we talked last time, we talked about some dollar thresholds as it related to self-disclosures. So I would say that generally it would sort of track something along those lines. There's no particular dollar threshold, that they will um, look at or ignore. I mean, certainly if it's a low dollar threshold, a low dollar case, but there's allegations of patient harm, right? That's going to be a different analysis than something that's just a low dollar case without that. Um, but you got to figure the dollar amount has to be such that it makes it, worthwhile to invest the resources in investigating it and settling it.
so one thing I think would be very interesting for the audience to hear about is, okay, so you decide to pick one of these cases. What goes on, and what should they know that's been done before that contact to the provider? So I didn't get a subpoena yet, I didn't get a letter yet, I didn't get an inquiry yet. So before that happens, before that moment when the provider knows, or at that moment they receive something, what should they know the OIG has done in the background? Unless you're going to tell us, oh, they're just issuing subpoenas without doing anything, which
No, 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 no.
say.
I would say, if you're getting a phone call or a subpoena or a letter from the OIG, in particular, somebody from the affirmative litigation branch, I think it's fair to say, or it's safe to assume that the attorney has reviewed claims data and that they have spoken to, if there's a complainant or someone from the hotline, they've probably spoken to that individual. That individual may or may not have provided them additional documentation. They may have had some conversations with beneficiaries. That's kind of where at least the preliminary look or the kind of the initial cut. That's the sort of work that they're going to be doing, and then in addition, they're going to be making sure that whatever the alleged misconduct is that it's actually misconduct, and that it's that a case under that theory would be legally supportable.
Right. So you've done the analysis to have a reason to believe that something unlawful has happened based on either data, interviews. And do you have other investigator type resources available? Do you have agents available to you to assist if people need to go out in the field? Do any field interviews occur beforehand with the OIG, or is that more along the
Yeah.
U.S. attorney lines on the investigation?
Yeah, so again, it sort of depends on how it comes to us. Certainly, if there were interviews that were done in advance of it coming to ALB, so for instance, if it was a case that was referred to us by DOJ, we may look at DOJ's file. We may review interview transcripts of things that they've done, but within ALB. We obviously have a couple different mechanisms. If we want to just go out and talk to somebody, we do have a chief investigator who can do that for us. It's someone who's detailed specifically to ALB. And then also, as you mentioned, we had the other two mechanisms that we have are subpoenas, both for testimony under oath and or document subpoenas.
Okay. So now that they know what's gone on before the contact, let's talk about, the reach out. What are the ways that the OIG contacts a potential, target? Who does it? And then we'll talk, I think, a little bit about, what should, let's talk about, good provider behavior versus bad provider behavior
Sure.
in response.
Yeah. So the main ways in which a provider would be expected to hear from ALB would be either through a phone call, potentially an email, but most likely a phone call, or what we call a pre-demand letter. And that pre-demand letter basically is like a 1 or 2 page letter that says, dear Mr. or Mrs. Provider, we believe that you have CMPL liability for this time period, for this conduct, and for the following reasons. And we invite you to come and, have a conversation with us. So, either a phone call or a letter. Occasionally, you might just get a subpoena. Just come straight to you. And I
Yep,
think
I've seen that. I've seen that
yeah,
more often.
right. And then occasionally, if, like I said, if it's a referral, then then from DOJ, for example, then typically there's an intro, uh, from the DOJ attorney to ALB, the ALB attorney, getting introduced to defense counsel.
Okay. And so now that subpoena hits the desk of somebody at a provider, or that phone call comes in, what is it? We can talk about what you should do, but what are good things and what are kind of the bad things that you would see, in terms
Yeah,
of
yeah,
response?
yeah. So I think first off, if OIG can get the information that it needs without having to issue a subpoena, they'll do that, right? And I think that sort of goes a little bit to your question about good provider behavior from OIG or ALB's perspective. I think the two most important things that you can do is to communicate and to cooperate. Um, so if you get a letter, or if you get a phone call, or if you get a request for information from the ALB or from OIG generally, it's certainly a prudent move to contact an experienced healthcare attorney with with a background in government investigations, and let that person help guide you through the process. But certainly, I mean, there are certainly people who choose to go it unrepresented. But either way, there's
How often do people try to do this unrepresented, and would you recommend that
I
in
would
terms of
I,
process, ease
yeah
of
I
investigation, things like that?
yeah, I'd say it's probably a pretty small number, a small percentage. Where I typically see it are sort of, small mom and pop kind of organizations, like the family chiropractor, or, a small DME supplier or somebody like that. I think that it's not, I would not recommend it. And I would not recommend it largely because I actually think that having someone who is not an attorney speaking to an attorney, I think that it makes it difficult to get the information that you need to be able to either further your investigation, close your case, or settle your case, right? So I think the biggest challenge with quote unquote lay people, or unrepresented folks that they have with when working with the OIG is that it's everything just seems to take longer. That's really not in anybody's interest, I don't think.
Yeah. Okay. So, what are things that you would say you've seen that are, you know, not a good way to get off that in your experience you've seen people do? Is it just the ignorance, just not responsive? Is there, any kind of other, you know, kind of misconduct that you've seen people engage in that really make things a lot worse for them?
Yeah, a couple things. One, I think one mistake is that frequently when when we reach out, when OIG reaches out to someone, you'll the first thing that you'll get is sort of complaints, from a provider or from their attorney, and I don't think that's particularly helpful. I mean, an OIG's position would be, listen, you chose to voluntarily participate in the federal healthcare programs, Medicare, Medicaid, and others. If you don't like the rules, then you don't have to participate. So, we heard a lot of times when I was there, well, the rules are confusing and this is difficult and, and all of that sort of thing. And there, there's definitely some credence to that, to that viewpoint. I think that, the counter argument would be if you don't know the rules, then, go find someone who can, who can help,
Yeah.
who point you in the right direction.
I was thinking about things that we've experienced, more of, make sure, one of the things I would say to everybody, and I'm sure you'll agree is best practice is start preserving your records, right? If these things are coming in and you're getting asked for things, make sure you implement, we call them litigation holds, but a document retention. You turn off auto delete if it's going to be something that could be deleted. You don't want to and the other thing that I see some providers do, is they panic and they go in and try to call, clarify their medical records sometimes in their words, and they'll start editing them. It's a huge no-no, from just their defense counsel, but certainly, from your point of view, the OIG's point of view too, wouldn't you say?
Yeah, I think that's a big mistake. So in addition to being unresponsive or promising documents or promising information and then sort of not following through on that, OIG recognizes that, people get busy and things happen, but, but if you say you're going to do something, you're going to provide something, then please do so. But I think two of the biggest ways in which people, get in trouble is what you just described, sort of trying to go back behind it after they know that OIG is looking. You're either fabricating records outright or kind of trying to clean it up, in a way that makes it, kind of more, focused or more, compliant. That's a mistake. And then I think too, as well, and I'm thinking this is jumping ahead a little bit, but I think the other thing is towards the settlement discussion. But the other thing is, if you're misrepresenting your financial position.
Right. Yeah, we can definitely get into that. Why don't you give the audience kind of a look at, what kind of your burden of proof is and your evaluation, and kind of then the interaction, let's call it the pre-settlement phase, where there is advocacy going on both sides.
Sure. The other thing I would add to the sort of the bad behavior category would be,
Right.
trying to shift responsibility to a third party. That's generally not successful, like a third party biller, for example. But as far as the burdens of proof, if you think about the criminal cases, that's proof beyond a reasonable doubt. That's like law and order stuff. If only the cases would take be resolved in 1 hour and have some cool music in the background. That not the case in OIG's world, but civil cases then are looking at, the standard of proof is that something is at least as likely as not, and that's essentially like a 51% chance or greater that the thing that we think happened. And that's the standard that ALB uses also. So they're considered an administrative remedy. So there's criminal, there's civil, and then there's an administrative remedy. ALB's work falls into that administrative remedy bucket, but they have that same burden of proof that it's at least as likely as not. And then there's an intent requirement under the CMPL that they have to satisfy as well, which is that the provider either knew or should have known that, and then fill in the blank.
Right.
And when they talk about that, what that really means is that's a standard that also mirrors the Civil False Claims Act. And when we talk about knowledge, that they knew, that means actual knowledge. And then should have known is essentially, that you were deliberately ignorant or that you demonstrated some sort of reckless disregard as to the truth of the matter.
Right. Sounds a little like the False Claims Act, eh?
Yep.
Yep. So we talked a little bit about, I've been in these matters with the OIG, and we usually go through, a period where we're making presentations or where, pushing back on different arguments. I have found the most effective arguments is either to push back on the facts, or to have kind of a reasonable explanation for, the conduct that's less in line with unlawfulness and more in line with either a, genuine, I wouldn't call it a misunderstanding and a lack of knowledge, but where it could be something either through CMS guidance or otherwise it was misinterpreted. But I know, yeah, if you come in and blame a third party, you're going to say my biller just did it this way. I know those aren't winning arguments. What are other things that you've seen effective in the advocacy side of things as you're pushing towards a settlement on the defense side? And how is, what are considerations you should give as you're trying to kind of whack away at the scope of the monetary damages? What have you seen over your times that you can think of?
Yep. So I think the three sort of most effective lines of pushback, if you will, for defense counsel, one is going to be that you're gonna disagree with the facts of the case, and you're going to explain to the OIG why their understanding of the facts is not accurate. And that's the good. What I will say is that there's ample opportunity for defense counsel to do that. So OIG will oftentimes share some information, maybe claims data, with defense counsel and invite them to make a presentation either on the data or the facts or whatever. And that's a really important mechanism that defense counsel has at his or her disposal to get the client's side of the story into it. And so you can look at the facts of the case as something that can be challenged. Certainly the way in which damages are calculated or the time period or the methodology, those are certainly things that can be raised as potential areas for conversation. And then the third one would just simply be that if there are multiple interpretations of a particular statute, regulation, guidance document, that helps move the needle as well. The more ambiguous it is, the more litigation risk ALB has, and the harder it would be for them to make their case if it went to litigation.
Right. And then, I'm thinking through some of my cases with the office. What about how does the OIG respond to either, the attorney or the advocate who just is not, willing to concede what I would call the kind of obvious, facts, things that are just, undeniable, and not willing to concede any liability during it. I've certainly been, as a prosecutor on the other side of things before. I've experienced that. I'm interested to see how that goes with trying to reaching a beneficial settlement for a client.
Yeah, I mean, sometimes what I would tell defense counsel before we even started having a conversation is that, we each have a role to play. At the time, I'm from the OIG and you're from, defense counsel. Our interests are different, right? But ultimately, the goal is either to get an understanding of the facts and circumstances to figure out whether there is a case there or whether there's not. If there's not, then we'll move on to the next one. And so I think that the sort of the rigidity or the kind of refusal to kind of concede anything or talk about anything in a productive way, I think that hampers the process, because ultimately, if you think about it, if you're looking at it from a resources standpoint, OIG wants to know whether there's a case there, and if so, they want to try to bring it to resolution, to settlement, right? They will litigate it if they have to. I would say litigation is rare, so that there's a very high percentage of cases that are brought or that are referred to ALB that settle. And so if you're sort of going into it with the idea that, hey, listen, we're going to try to settle this so we don't have to go to litigation, and it would be in the client's interest not to litigate, then hopefully that sort of breaks the logjam a little bit in terms of having some productive dialogue.
Right. Right. So let's talk about moving towards a settlement. And one thing that I'm interested in is how soon are you along in your investigation contemplating the type of resolution that's going to be needed here? For example, is it monetary alone? Or are we talking about exclusion or integrity agreements? Like how soon are you all thinking and more, we're not just thinking about it, but evaluating those things?
Yeah, I think all three of those things, whether it's a monetary resolution plus integrity obligations, and or some combination of the both plus exclusion. I mean, those are things that are going to be discussed from the outset, right? From OIG's standpoint, at least internally, they're going to be discussed,
Right.
and sort of get a sense of, all right, this is sort of the case as we understand it, and this is sort of what we would think, whether or not what a potential remedy in this kind of situation looks like. And obviously that discussion is ongoing and can evolve as the investigation moves forward too. But what I would say is that each one of those remedies or solutions, they're considered throughout the process.
Right. And so how soon is it, would the OIG be either receptive to counsel with the provider inquiring of whether exclusion is on the table, or is that something that gets addressed further as we get into the settlement, which is really the next part of our talk here?
Yeah, so I think it depends on the facts of the case, but again, if the OIG is always going to give the provider and or his or her counsel the opportunity to respond, right? And so you use that response not only necessarily to address the specific thing that OIG is asking you about or asking you for, but it's also a great time to start laying the groundwork as to why it is that you think your client should not be excluded, or why it is that you think your client does not need additional, integrity obligations thrust upon them, in addition to whatever the monetary settlement is. I would say it's never too early to start, having expressing those thoughts to the OIG, because number one, I think it shows that you're serious counsel and you understand what's at risk. But I also think that the earlier you can talk about it, the earlier they may say to you, "Hey, listen, this conduct is not, it's not great conduct, right? But it's not. We would not believe it to be exclusion worthy, right?" So then therefore we may just be looking at a monetary settlement, or we may be looking at a monetary settlement, plus integrity obligations, whatever the case may be. So I don't think there's any harm in broaching it, because the earlier you know what the government is thinking, the better prepared you are to respond on your client's behalf.
Right. And then, we're going to get into settlement now, but here's a question that came in from one of our attendees here is, let's say you decide, you look at everything, you talk to the lawyers and you decide, you know what, we're not going to, or at some point along the line, you decide you're not going to pursue, the OIG is not going to pursue a case. Is it a normal practice to inform the provider that the investigation was concluded and they're not moving forward with an action? There was a comment that they haven't really seen this communication from the OIG before. So,
I
is it?
think that I think yeah, I think it depends on the attorney handling the matter. Um, Generally, they're never going to provide that to you in writing. You may have a conversation with someone in which someone from the OIG calls you up and says, you know what, we looked into this matter, and we found that the allegations are not substantiated, so we're going to close the case and move on. That you may get an email like that. It's pretty rare. It's more likely to come verbally. And there's other times where, for whatever reason, OIG decides that they're going to close a case, And in the response that you might get from the OIG attorney is, well, um, we are not going to pursue the matter at this time,
Right. Okay.
right? Those are sort of the two ways in which it's normally phrased.
All right. So why don't you then walk us through the unfortunate times where the provider isn't having the case closed and it's now time for a settlement? What goes on behind the scenes? What are you putting together? What are the components that you really need to work on as the OIG attorney?
Yeah, so I think that generally speaking, the OIG attorney has quite a bit of latitude, to try to get the matter to settlement, and let's this sort of the next part of this conversation is premised on the fact that there's at least sort of a tentative agreement to settle the matter, right? And so I think that the things that are going to be happening behind the scenes are a couple things. Number one, the attorney is going to start drafting a settlement agreement. And with respect to that settlement agreement, they're going to be particularly focused on the description of what's called the covered conduct, or the conduct that's at issue. So describing that conduct, making sure that they can articulate the dollar amount, and then with those two pieces, behind the scenes, they're going to draft what's called a settlement authorization memo, which goes up to the deputy branch chiefs and then ultimately to the branch chief. And that memo is we say it's a memo. Sometimes it's short and sweet, and sometimes it's not, and it's long. But a lot of it, the memo itself talks about the investigation, the factual basis of the case, and resolution, and the proposed resolution, how damages were calculated, what multiple, if any, is going to be applied to that damage calculation, whether there's an ability to pay the settlement amount, whether or not integrity obligations or exclusion are appropriate. So all of those types of things are generally going to be covered in the authorization memo, and it goes up. They'll send it up, it gets approved, and it comes back, and then the settlement agreement, the draft settlement agreement, will go to defense counsel. They'll review it. They can recommend edits for certain things, but I would say that as a general matter, the agreements that the OIG uses, the settlement agreements, are largely boilerplate.
Yeah,
And
yeah, they are. And the response I've received from my counterparts in the government is generally they really avoid making changes to more of the standardized paragraphs because these are generally getting subject to FOIL or FOIA requests. They're getting compared by defense attorneys out there. They don't want to be able to say, I've done it in one and not another. So I've experienced that a number of times, but there are areas where we can make headway. And I'll let you talk about it. Usually it's in, things like covered conduct and making sure your releases are appropriate. But why don't you talk about that, and then maybe talk about how you get to the damages numbers as well for settlements?
sure. So I think that you're right. There OIG places a premium on making sure that similarly situated providers get treated similarly, right? And that is permeates sort of the way that they do business, from opening a case through settlement. They're very keenly aware of making sure that similarly situated providers get treated similarly for the reasons that you just stated.
Yeah,
With respect to sort of where you can make some headway in the settlement agreement itself, I think it's largely related to the covered conduct is sort of the biggest thing that they're willing to entertain. And then I think that the other areas are really just sort of making sure, as a defense attorney, that you're doing your due diligence, right? Making sure that the permissive exclusion, the release for the permissive exclusion is in
right.
there. And it's also about, making sure that you have the right signatories, and also just to be sure that if there's a provision that you don't understand, to get clarification. on it from the OIG attorney.
So on that point, right? So we decide, okay, we have some liability here. We're gonna enter the settlement agreement. One of the things that's always big is no admission of liability for our clients. The other thing is explaining what are they getting. What is the benefit of their bargain by signing this agreement, and what aren't they getting?
Yep.
What is that release covering, and what doesn't it cover? And let's talk about kind of some of the tentacles that come from that as well that we have to address with our clients and with the OIG.
Sure. So I think that a couple of things. The sort of the biggest benefits to settling the matter with the government, with the OIG, is that that as part of that release, at that settlement agreement, almost always, and if it's not, you can ask for it to be included, but almost always there's a no admission of liability paragraph in the settlement agreement. And then in exchange for the settling and paying the money, or paying the money and doing the integrity agreement, which is a separate negotiation. What the provider gets out of it is a release of OIG's permissive exclusion authorities. So if you remember from the first session, we talked briefly about the exclusion authorities. Some of them are mandatory exclusions, that are mandated by Congress, and those are largely related to matters where there's a conviction. But because there are so many other permissive exclusion authorities, what they're getting is a release of OIG's permissive exclusion authorities for the conduct as it's described in the covered conduct paragraph. And so that's important, because that signals to the provider that they don't have to worry about what OIG is going to do with it next. Like, as far as OIG is concerned, this is the covered conduct, we've settled it, and we're moving on. So I think there's some peace of mind there. And then I think too, as well, since there are cases that OIG originates on its own, that it's not to say that DOJ would not look at the same conduct. But for example, if a provider entered into a settlement agreement with OIG, and then DOJ comes behind later and says, hey, we want to talk to you about this very same conduct for this very same time period. If I'm defense attorney, I'm holding up the settlement agreement saying, hey, look, we've already resolved this with the OIG, and it may not be enough to persuade DOJ to pivot to a different matter or a different provider. But a lot of times, in my experience, it is. But again, I can only speak to my own personal experience. The thing that you don't get with the OIG settlement is that you don't get a False Claims Act release. So False Claims Act is the purview of the Justice Department, and they typically do not participate in OIG settlements. And I've had providers ask me, well, my client, or I want an FCA release for my client. And what we say is, hey, listen, we can't give you an FCA release because that's a DOJ action. If you want me to, I can call DOJ and ask. And usually there's a subsequent conversation that's well, what's the risk of that? Well,
Right.
you may not be
That's
on
the
DOJ.
question, right?
Yeah, you may not be on DOJ's radar, but if I make a phone call to DOJ and say I've got a provider who's engaged in this and they want a False Claims Act release, chances are that that's going to open up a bigger can of worms.
And certainly slow down the process too, right?
Yeah, absolutely.
So a quicker resolution and put it behind them.
Yeah, if nothing else, it throws a monkey wrench into the settlement cog there. So that's just.
But it's kind of a funny thing, because usually in our False Claims Act settlements, we're asking to speak to the OIG because we're fearing, the exclusion authority or potential integrity actions coming against us. But on the other hand, when it's reverse, there's some trepidation there.
Yeah, I mean, I can't speak to why it is, but it is a one-way street, right? If you're primarily working with DOJ, at some point OIG is going to be brought in to do two things. One, to be a co-signatory on on a settlement agreement, an FCA settlement agreement, excuse me, and to assess or to negotiate integrity obligations if they're needed.
Right. I'm just trying to respond to somebody. We have a question here, but we need some more information.
Okay.
Let's see here. Anything, you have any other thoughts that, as we kind of, what about, okay, big one is, that's great. Thanks. You've determined that I owe $3 million, but I've got, $47 in the bank, and a pretty large mortgage on the house, and I don't really have the cash to come up with your settlement, Mr. OIG,
Mm.
attorney. What are the avenues available then?
So yeah, so that's actually fairly common. And the other thing I would say, the other benefit to settling the case with the OIG is in how the damages are calculated. And this sort of gets to your point. So under the CMPL, the OIG can seek to recover up to 3 times the amount billed, plus additional monies. And generally speaking, when you're in a good faith negotiation settlement posture with the OIG, their general baseline calculation is going to be looking at, well, what's the amount that was paid rather than the amount that
Right.
was. So there's another added bonus there, to the provider is that they're already they're cutting you a substantial break on the amount of money that you'd potentially be paying. And then to your point about like dollars, like um, providers and their attorneys, to the extent that as you get into the settlement process and you get further down the road, the OIG is going to explain to you kind of what the dollar amount is and how they've calculated it. And if in conversations with your client, it's clear that they don't have that kind of money, then what you would want to, that's an issue that you would want to flag for the OIG attorney, as early as practicable. And what that will trigger for them is that they will send you individual and business financial disclosure forms, and those forms ask the providers to give a snapshot of their financial picture, both individually and if it's appropriate as a business, and then to
Well,
provide some.
a snapshot is, I think you're being generous. It's a pretty healthy look in my experience for some of
Yeah,
our clients. It's,
yeah, yeah.
you don't get to write down what you think because there's certainly a
Mhm.
lot of financials we have to turn over.
Yeah, yeah. So with that, kind of with that form, there's a request for a bunch of supporting documentation.
Yeah, yeah,
Right?
yeah,
So I think when I mean snapshot, I think they typically look at the last 12 months.
right.
Uh, but to your point, there's a fair amount of supporting documentation that has to be provided.
Yeah, and where can you go awry there? I think there's kind of an easy answer here,
Yeah, I
but
mean, I think the mistake that people make is just not being forthcoming,
right.
and or trying to shelter assets or hide things from the government. Um, and that's a mistake, right? That's never going to endear anyone to the OIG if you're doing that.
Okay.
Um, but so what ends up happening is then the attorney will do an analysis looking at the financial records and sort of make an assessment in terms of what they believe the provider can pay. And part of the sort of the two, so that's one of the flexibilities, if inability to pay is raised. The other one that anybody can raise, to a point, is there is some payment flexibilities in terms of the timeline. So ordinarily, the settlement agreements, payment is due within 5 days of having a fully executed settlement agreement. They will give you up to 6 months, to pay that money, without interest. But if you go beyond the 6 month period, then you have to demonstrate inability to pay and fill out the financials and all that sort of thing. But the payment flexibility that they're offered, they will take the payment term all the way out to no more than 5 years. But any payment term that's in excess of 6 months will have an interest rate attached to it. And that interest rate is the one that's used by the Social Medicare Trust Fund, which changes monthly. But it's generally pretty low in the 2.5%, somewhere in that neck of the woods. But if you go sort of to the end of that spectrum, 5 years, you can rest assured that OIG is going to want a pretty significant payment upfront. I would say that those 5-year terms are pretty rare, especially these days. But it's not uncommon to see somebody ask for 2 or 3 years, and then as an attachment to the settlement agreement, you'll get a payment chart, that explains to you what the amount is and what the principal is, what the interest is, and what you owe, and when the payments are due. So
Yeah. So we got about 3 minutes left here. We have a good question come in, and it's kind of like, I think it's a good place to end, like talking about exclusion, because it's everyone's fear. It's the death of your practice or your business. So one thing I'll say is, let's just quickly talk about effective ways to try to push, if you have an OIG attorney, really on exclusion, what are things that you would do to come to the table to try to alleviate that? And then the question comes in is, how negotiable is the 3 to 5 permanent exclusion, and what plays into the decision on it?
So the first question was about things that you can do. So I think that a lot of times, when evaluating whether or not there's a candidate for exclusion, right? OIG is looking at it on sort of a continuum of risk, right? And so there's a variety of factors that they're going to look into, right? How long did the conduct go on? How much was the dollar amount? Was there patient harm? Did they receive education about it previously and continue, to do it, improperly? So there's a lot of factors that they sort of look at to determine whether or not somebody is a candidate for exclusion. I mean, I think that a couple of things that you can do to potentially stave off exclusion, or certainly lessen the length of time, would be to talk about if there are any mitigating factors to the conduct, if there are certainly the expectation would be that whatever the conduct is stopped. So if you can point to the fact that you stopped the conduct and that you instituted sort of corrective measures or actions to ensure that you don't fall into the same trap again, I think those things go a long way to giving the OIG attorney good food for thought in terms of.
Yeah, usually I go with the ideas of you've gone to your client with the identified conduct, and you've either hired a consultant to come in and help them with it. Is it education and billing and monitoring the billing to ensure that it's not happening again? Is it a grant issue where we have some real issues with weakness in their business operations that need policies and oversight, and coming forward and making a presentation on that to say, kind of hold off here, please. Let's maybe an integrity agreement, or you don't need anything at all, we'll do this ourselves. So that's, I found to be relatively, pretty well received. But the other question was, kind of what goes into your consideration, and how the flexibility. I'm not sure about that.
Well, there's the mandatory exclusions.
Can't do anything.
I'm sorry, the mandatory
Yeah.
exclusions. There's certain time limits there, and then as a general matter, when you're talking about permissive exclusions, there's a mandatory either 3 or 5 years for permissives, right? And so there's no wiggle room on that. If it's a permissive exclusion and the statute says it's 3 years, it's 3 years, or if it's 5 years, it's 5 years. I think that where people often try to sort of work backwards is if the OIG is proposing something that's, in excess of
Got it.
those years.
Okay. Well, this has been, I think a very, very good, webinar. I'm glad that we're here and bringing this kind of content, and more importantly, your experience and insight to our clients, our community, and we're going to continue that, everybody, because you'll get notifications about it. It'll be in the email tomorrow, but we've got part 3 of this coming up as well. So that's going to be next month, and I'm just double checking the date we picked for that. But that is on Wednesday, October 25th at 12 o'clock. And there we'll be talking, David, about the OIG's role with the, resolving that False Claims Act liability, and kind of what we just alluded to before, the one-way street. So I think, we teed this up, and people, we really look forward to everyone coming back. So thank you, David, and thank everybody for joining us today. All right, you are welcome. You are welcome. Receiving, David, a lot of compliments. So you did a
good. Well, yeah, happy to be here. Thanks for having me, and I'm glad to share the information.
Yep, at Garfunkel, we'll keep these going for you all here between compliance and others. You can stay up to date on all other topics as well on our website, and we're happy to have you all join us. So have a great day, everybody.